So still going on.
And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable interest based on that footnote in the Williams case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship. That's the original sin from which all of the other problems flow. There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification, but collectively, practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment of the relationship and the money. Fourth, the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense of this motion to disqualify, especially the hearing. On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle is whatever impairs the independent professional judgment of the lawyer. That is applied routinely. We have a county code section that flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 U.S.C. 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory based on State v. Thomas, 311 Georgia 407, particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began, each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which she was previously chastised by Judge McBurney, and that's also present in this book. The inside flap of this book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book. I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the county code prohibits gifts from prohibited sources, which he was. There's no boyfriend exception. The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false, and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy train rolling for as long as possible. His part in the pattern of concealment is the story you see in many divorce cases. The husband is hiding things from his wife. How much money he's making, the other woman, and what he's spending on the other woman. And he got on that stand, he lied in his interrogatories, and then he got on the stand and he lied about lying in the interrogatories. And the lawyers for the DA's office, they just sat there and let him do it. They did nothing to correct obviously perjured testimony. In and of itself, that warrants disqualification of every one of them. The reason they lied and covered it up was to avoid the trouble they're in right now. That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church, I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex Doctrine on the grounds that she's the DA. The whole filing is expressly predicated on her status as DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation. In the prayer for relief on page 11,
I want to give a shout out to Output Arcade, which is one of my favorite plugins. And of course, if you'd like to try out Arcade,
filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it. That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. She violated her public duties not to make that kind of a threat in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state, but the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning. But now they've enlisted the entire office in the enterprise. In the written response to the motion to disqualify, they said this, and I quote, "To be absolutely clear, there is no evidence that D.A. Willis derived any financial benefit from Mr. Wade." That's on page 15. Flat out false. 10 lawyers in this case put their name on that. starting with the DA. So throw another log on the bonfire of conflicts of interest. The problem was between her personal interests and ambitions on the one hand, and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified. If this is tolerated, we'll get more of it. This office is a global laughingstock because of their conduct. They should be disqualified and the case should be dismissed.
Your Honor, there's not much oxygen left in the room. We delineated the times based on the whole presentation. Would Your Honor consider some time for us in rebuttal?
No.
Okay, well then, could I reserve what I had, 5 minutes for rebuttal?
Sure, that's fine.
All right, thank you, Your Honor.
All right, let's take a quick 5, and we'll be back at 2:40-ish to hear from the state. Thank you.
If you're struggling with writing chord progressions, I have a simple yet powerful tool that allows you to instantly create amazing ones without spending years learning music theory, without any mind-numbing trial and error, without spending any extra time. If that sounds interesting to you, click the button below to check it out. Over 50,802 producers are already using this simple tool and making all the crazy chords and progressions they never thought they could. This doesn't require any music theory experience, it doesn't require thousands of dollars at music school, and it does not require sitting there trying to plug in notes in the piano roll. Literally as simple as a drag and drop, you can create any chord progression that you want, anything from simple to advanced, and they sound absolutely amazing. So to learn more and discover what the simple tool is, click the button below and I'll see you on the other side.
You have to be ready. Let's fight like demons. Most impressive. Ah, my boy!
This is only the beginning. That was insane.
Dune Part 1, now streaming on Max. And Dune Part 2, now in theaters.
Mr. Wade, and once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that Mr. Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that's where the state would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Ms. Merchant a liar. I never used those words. I don't know why she made the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago, as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Ms. Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Ms. Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation. Those were the specific references that he made. So what I would submit to the court is those are considered adoptive omissions that his client has made based on the statements he made because of the representations she made to him. So, and I know that sounds convoluted, but what I would say to the court is Ms. Yurdy told Mr. Partridge, because Mr. Partridge told the court that she had absolutely no information about a romantic relationship, and she had absolutely no information in regards to...
So, but wait, are you making an argument I should make inferences based... Now, these would be attorney-client privileges, or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is, that's why she's hired him, and you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing. The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that, 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Ms. Yurdy, when she testified, was vague, very little description. When asked in a very leading manner, is it true, or do you know that Ms. Willis and Mr. Wade were in a relationship from 2019 into the time you were fired, or excuse me, you were forced to resign from the district attorney's office in March of 2022, she said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Ms. Yurdy's testimony, that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Ms. Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd. It's absolutely absurd. More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations, she said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw, was it a kiss on the cheek, things of that nature. So I would ask you to frame her testimony from that standpoint when you're addressing her credibility, as the court is going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing. I'm going to see if my screen will share.
She started doing some of this shit to me. Pissed.
Now, I want to talk a little bit about the standard and the burden here in this instance as it relates to defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from Cornell scholarship reading or publication, and they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason. And that goes along with the standard. What the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Ms. Willis received a financial benefit or gain and got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple defense counsel, they still got nowhere. We're in the same position we were in on Monday. The same assertions that were made on Monday have no answers today as we're before Your Honor. They were not able to provide any evidence as to, or to the contrary, of Ms. Willis and Ms. Wade's assertions of when their relationship began. There's absolutely no evidence that contradicts that the relationship did not begin later than or around March of 2022, Your Honor. I'd further submit to the court, because of this failure, that their assertion or their request that, one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights, have been harmed in absolutely any way. There was zero evidence. Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights, were at all affected by the relationship that began in March of 2022 with Ms. Willis and Mr. Wade. And because of that, the motion to disqualify should be denied. And Ms. Willis, as the District Attorney of Fulton County, and Mr. Wade, as the Special Prosecutor assigned to this case, should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to what the issues are for you to, I guess, determine. And here it would be the state's contention is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify Ms. Willis and the district attorney's office. And looking at
What?
I think you're talking about, is this Ventura?
It's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that what the standard is that is a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor. And I want to go through some of the cases that defense counsel has referenced as they argued here today and in their filings. And I guess the bright line standard, or the standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney, is you either find that there's a conflict of interest or that there's been some sort of forensic misconduct. Those are, I guess, the two areas that Your Honor that is in your purview when you are looking to resolve an issue regarding disqualification. Now, in a recent case, Lee v. State, which is 224 Georgia, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is the case that was ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel have relied on in their briefs and here today, I would submit to the court the cites are misleading, are inapplicable, and some of them actually support the state's position. And what I would say to you is that the defendants, in many instances, combine language from the multiple cases and kind of what I would say is misstates the law as it relates to what the law or what is required in order for an elected district attorney and their office to be disqualified. And what I would submit to the court is...
Let's go back to that. Show me how.
Yes. Show you how.
So I think the first one they cited was Battle versus the state. Certainly a conflict of interest or the appearance of impropriety would be the grounds of disqualification.
Well,
there are a number of these cases that seem to exclusively rely on the appearance of impropriety.
Right.
Well, they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. But they acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court, is in all of those cases, they do reference the appearance of an impropriety, but they reference that because they also find there's an actual conflict in each one of those cases.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of a propriety?
As it relates to a prosecutor or district attorney, yes, that is what I'm saying. What I would say is, in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an appearance of impropriety, and those are what those cases stand for. And I guess that is the main example of what I reference as they kind of combine the language.
Hi everyone, Mark Barden here at Sandy Hook Promise. On December 14th, 2012.
That is not the standard. And in my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that appearance arose from the fact that the court found an actual conflict in each one of those cases. So I won't belabor the point in going through all of the cases that the defense had cited, but what I would submit to the court in reading those cases is that I found that they kind of fell into 5 categories. That some that didn't concern disqualification at all, some that determined or that were about, I call it divided loyalty, which is a conflict that arises from representing becoming a prosecutor and then having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome, and then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case after conviction. And these are some of the cases that defense counsel had cited within their brief that had absolutely no application to the issue that we're here before Your Honor today. The first, McIver v. State, has nothing to do or has nothing related to the disqualification of anyone.
I mean, I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there. But if there are more, all right, keep going.
So as it relates to one of the cases that was referenced here earlier and is also referenced in some of the briefing by defense counsel is the Regestive v. State, which is 287 Georgia 542, and all of the cases that fall under this, what I would call category, is about a attorney who formerly prosecuted a defendant in I guess the same type of case or the same case or similar charges, and that would be why the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor. The next series of slides just goes through what has been addressed as it relates to the standard that is required when dealing with the issue of disqualification, and the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified, and that actual conflict has to be in the form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case. Like many of the cases that involve personal interest, Your Honor, it's all based on a contingency fee, where how much they're paid, or a bonus, for example, is dependent upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips, and if didn't pay back in cash, it was
all right. Let me explore this one a little bit. So, in addition to you're saying it's only an actual conflict. Are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about? Or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win? Well, now they've got an incentive, if one of their officers is lying, not to tell you about it, because they want to win that motion to suppress. But maybe that doesn't affect the outcome, because you can win a motion to suppress or lose it, and that doesn't decide whether it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that would be an instance where disqualification would be necessary and appropriate, because it's a situation that involves a contingency fee, and I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right? But if it's some immaterial, I don't know. But I guess, so you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, no pros at the end of the day. It is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning, or how, if you win a motion to suppress and if you win, you get, a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case, because, as Your Honor just said, if there's an instance where an officer is lying, or where there isn't a good faith to go forward with that motion, the prosecutor would go forward with regardless, because of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case, because if they were to win a motion to suppress, or I guess the motion would be denied, and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case. So I think it's twofold, as Your Honor has referenced. I think it's at that part of the procedure of the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency, but ultimately that action during the procedure will lead to the ultimate outcome of the case being or hinging upon a contingency fee like the ones in the cases referenced by counsel and the state that are on the screen.
So getting into the language again, what you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen, and that's the reference, or why the state referenced that case in relation to the argument that an actual conflict is required. In the series of cases, Young, that was referenced by defense counsel, as well as Nichols, these state are both instances where there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim, which are what both of those cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, but there's, they refer to the metaphor of Caesar's wife, and generally when that's used as a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world?
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would differentiate, I guess, the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court, and the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown. So, a series of slides all about Whitworth. So I go back to what we referenced earlier, what's been referenced by all parties, that the grounds in which disqualified is where a conflict of interest is found, and where there's forensic misconduct that is found. Those are the two grounds that are to be, I guess, are within the purview of the court as it relates to the issues here. And again, I go that was Justice Pinson wrote about, and that it must be that by failing to disqualify the assistant district attorney absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling, and I think it's purposeful, I would submit to the court, because an actual conflict of interest is what is required in order for a district.
If you're tired of spending a ton on all your streaming services, then welcome to Philo. Say goodbye to cable boxes.
What I would reference to the court, as was brought up earlier in Lyons v. State, 271 Georgia 639, a 1999 case where it talks about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what has to be shown is an actual conflict. If it's speculation.
Is there any qualifier there, though, that's in a post-conviction context? So we're talking about, competent evidence. We're obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a totality: was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought. If you have any reactions.
Well, I think what Your Honor said is pretty